Hello everyone, Mastering the AI Act, what every AI entrepreneur needs to know. My name is Adrien Basdevant, I'm a tech lawyer. I have founded a law firm called Entropy. We help decision makers and entrepreneurs navigating throughout the complexities of AI regulatory topics and tech policy. I will start with a number. This is not over 9,000 meme from 4chan for those who know the reference. This is just 700. Anyone knows what that is about?
Number of pages.
Number of pages of the AI Act. That could be the answer. It's twice as less, but it's still a lot. It's actually the number of AI-related legislation that have been considered by states in the US since the beginning of the year. I think it's pretty interesting to know the volume that is increasing around that question. And you here, as either ML engineers, decision makers, entrepreneurs, whoever you are, you can ask yourself, how am I going to cope with all that complexity? How can I have a coherent global approach in relation to AI regulatory topics? And also, since there are so many piece of legislation and code of practice, you can ask yourself whether AI regulators are also few-shot learners. Do they need so much quantity to fully approach and tackle those topics? So the talk today is going to be around the number 10, not because I'm a huge fan of Zinedine Zidane, even though I am, but it's going to be 10 concrete takeaways on AI regulation, plus 10 minutes of Q&A. And the reason why I'm limiting this to 10 minutes, it's not only because I only have half an hour to talk, but it's because lawyers do talk a lot. But it's also because, we are often reluctant to any kind of legal reasoning, and we often tend to think that, oh, please don't talk with anyone that is around policy, regulatory, it's going to stifle innovation. Whereas my deep belief is that we have to build some innovation and still be responsible in the way we are building it. So this is why I've limited it to 10 key takeaways, and I would have done my job if by the end of that talk today you have remembered some of them. So number one, EU will not be the only regulated space. This is something interesting because you all know the saying that Europe regulates, US innovates, and China replicates. Well, in the US alone, since the beginning of the year, you have 113 AI bills that were enacted. Of course, it's not at the federal level, it's at every state level, but that speaks about this increasing volume of complexity and entropy in the way we're going to deal with those regulation. So EU is not going to be the only regulated space. Takeaway number 2, you have to distinguish in between binding regulation and voluntary code of practice. If you don't know the difference, I'm going to take a concrete illustration. End of August this year, there were 2 major operators, namely Entropy and OpenAI, that have signed an agreement with US AI Safety Institute to make sure they can test, evaluate some of their advanced models. And the question you should ask yourself is, was that mandatory? Meaning, those 2 companies, were they compelled by any kind of legal ground to share those models? And if they don't do so, are they going to have any consequence? Is it going to be enforceable? This is a good illustration. This is purely a voluntary move on their part. Maybe they can have, of course, reputational consequences and name and shame if they don't do so, but this is not a legal requirement. So I've just tried to simplify that for you. You have the difference in between legal obligation on the one hand and voluntary guidelines on the other hand. And you have to be conscious about those differences, because legal obligation is something that is a binding rule. This is set by law or any kind of regulation. The topical example being the EU AI Act I'm going to talk about in a second. But it's not the only one, and it's not going to be the only one. On the other hand, you have voluntary guidelines such as the international conversation we're having at the G7 level with the Hiroshima process, for those of you who know, but also last November in Bletchley near London, you had an AI safety summit, and the upcoming one is in San Francisco in 10 days, which are the reunion of institutes that are talking about international standards, for instance, on red teaming, AI testing. And those guidelines, of course, they're going to be impactful in the ecosystem, but those are not binding regulation. You have to know about that. So if there's a breach of any of those requirements, it's not going to have the same level of impact. So number 3, you have to understand the EU AI Act. Why? Because it might influence other parts of the world. It's like the act itself is not like the GDPR, which is the General Data Protection Regulation. It has a completely different philosophical approach and also practical approach, but it has the same extraterritorial consequence. And you know, the GDPR throughout the world influenced a lot of other regions. For instance, in Brazil, in India, Canada also have the same approach. So again, you should know what's in the EU AI Act. Not fully, of course, because it's not 700 pages, but it's still 113 articles. And you also have the recitals. This is the little text before the articles that talk to you about why those articles exist. And you have also annexes. So it's a really like good luck with that. It's pretty complex. And the objective is basically to improve the functioning of the EU market while ensuring a high level of protection in safety and fundamental rights. But it's not like a fundamental right piece of legislation. It's more about the possibility to place on the EU market an AI system, whether you are the provider of this AI system or someone who is deploying it, meaning, for instance, a company that is considerably modifying the AI model by fine-tuning it or adding some other data sources to it. You can be a distributor, an importer, a user, professionally or not. And it has an extraterritorial approach because it will deal with any AI system placed on the EU market, even though you're based and registered outside the EU. And also if the output generated by the model or the system is used in the EU. So there are different layers of penalties and fines, the maximum being 7% of general turnover or 35 million euros, whichever amount is higher. This is not the best way to think about the regulation because there are many configurations in which you're not going to be concerned by those layers of penalties, but still it's gonna have an impact. Takeaway number 4, regulation focuses on use case, not technology. So there is this pyramid of risk-based approach that is often presented, and I think it's a bit oversimplifying, but I'm still, as a general introduction showing it to you. You have basically 4 layers of risk. If you develop something that is socially unacceptable, such as social credit scoring, you're not going to be able to place the product on the EU market. And on the very bottom of that pyramid, for those who are in the back, you have minimal risk that are some AI system that may not have the same impact. So basically what you have to do as either a model provider or deployer, you first have to understand your legal qualification. Are you the one that is developing it, fine-tuning it, etc.? But then also what kind of use case is going to be developed out of it. So if you're in the high risk, for instance, in the medical device sector, biometric categorization or identification, also any kind of critical infrastructure in relation to energy, anything related to human resources, because a lot of people say, oh yeah, the AI Act does not like apply to me, but if you are using AI tools in your HR process, then you may be a bit, cautious about it. It doesn't mean that you don't have the right to use it. It just means that you have to pay attention with a different person within your organization, from product design, operational, legal, to understand the impact assessment that you should undertake before deploying or using those tools. So for instance, because it's pretty lengthy, and of course in 20 minutes I don't have the time to go into details, it's pretty small for you here. You have the high-risk AI system requirements as a provider that can go from setting a risk management system, so you have to document what kind of risk could unfold when using your system. If you're a provider, then you have some technical documentation, but also use instructions to share with the deployer. That raises super difficult question, because you also have trade secrets. So at the same time, you have to make sure that deployer know how to use the system, but at the same time, you cannot share everything on it, because of course there's also some secret sauce underneath. So just bear in mind that you have quality management system, accuracy, robustness, cybersecurity. Those are many topics that needs to be documented, and in some cases also you have to get some authorization. Takeaway number 5. I said in number 4, regulation focuses on use case, and except for foundation models. So foundation models, as you know, is the term coined by Stanford a few years ago to talk about what we legally qualify as general purpose AI model. Those are models that have been mostly trained by self-supervision, and that can be deployed for multiple use cases. And by definition, you don't know beforehand what it's going to be used for. So you understand from the previous principle that regulation is supposed to regulate use case and not the technology itself. It's like, a hammer. It's a dual use case. You can, use it for to hit someone, or just to put a painting on the wall. But it's the same for any kind of technology. In EU in general, what they want to do is regulate the use case and not the technology. But since this technology is multiple use, it potentially used for multiple use case, they did not know really what to do with it, because also the impact assessment done on the EU AI Act was undertaken in 2021, and when ChatGPT hit 100 million of users in few weeks, the text was already been discussed. So we're going to see in the future if EU regulators rushed on that topic, should they have included it or not. But you have to remember that what we call general purpose AI model, that is the equivalent of foundation model, one of the subset of it being marketingly talked about as a generative AI, is something that is being addressed with one main criteria, is whether your general purpose AI model has or not systemic risk. So this is pretty complex just in a few minutes, but if you reach a certain threshold, your model could be deemed as having systemic risk. Systemic risk can be defined by the AI office, that is an office in the EU Commission that also have a scientific advisory board, and they can determine whether a model falls in that category. But there are also other criteria, such as the fact that you are beyond 10 power 25 flops, floating operation per seconds. That technical criteria has been really debated. A lot of commentators in the ecosystems think it's a bad idea because, so in Europe, we have chosen 10 power 25. In the US, they took 10 power 26. small difference, right? If you are beyond that threshold, you are by default deemed as having a systemic risk. your requirements can differ whether you're providing an open source or a proprietary model. You have different, requirements that can go from technical documentation to model evaluation, watermarking, or copyright policy. So that is something that you should be careful about. Takeaway number 6, the AI Act is just the first layer. Sorry about that news. It's just the very beginning of something that I just put here. The implementation timeline is going to be lengthy. It's going to unfold in the next 2 coming years. It's not going to be, like the AI Act just came into force this summer and you're done. No, sorry. There are many code of practice that are going to come out. There are a number of delegated acts. Those are like secondary piece of legislation that are going to refine a bit the approach. So for instance, right now is being discussed a code of practice only for general purpose AI model. There's also a code of practice around high-risk AI system to know whether you fall within this category or not. That can be very tricky. It's not that straightforward whether you qualify it as high-risk system. And like when you're lost in the map, sometimes when you're in the subway, they tell you like, you're here, so you're here. This is you here, and this is us going like through times, and end of 2030 for those who cannot read from there. So it's going to be like there's going to be a lot going on, okay? So if you're in the ecosystem and if you're in this field, you should know a bit about it, not like in depth. It's like for me, I'm trying to read as much as many white paper as I can, but there are so many coming that you cannot follow everything. But at least you should have the general framework and understand that it's a progressive implementation. And also, number 7, you need to contribute to upcoming code of practice, because whether you're from civil society, academics, private companies, institution, we need to have different voices heard to know how to best define those upcoming code of practice. So for instance, there is a super interesting template that's going to be published by next summer 2025 that is around the sufficiently detailed summary of content that has been used to train a general purpose AI model. This is in relation to Article 53(1)(d) for those who want to go into details. It's going to be a key milestone because a lot also of compliance and litigation are going to be around this template. So depending on the granularity of this template is going to have a lot of consequence. If you're interested by it, you can take a photo and see how to contribute through the AI office or other means. This is just one example out of many. Just to respect the timing, I'm going to go through number 8, 9, 10 pretty quickly and then take a few questions. Of course, if you have other questions, since I'm not a bot and I'm not going to be able to answer all of the questions in a few minutes, you can just ping me, reach me. I'm in Paris, so it's pretty simple since we're all here. Number 8, AI regulation is not only about the AI Act. So sorry, because the talk was about, unpacking the AI Act, and I'm just telling you there's another galaxy. So yes, there are many, many planets all around that AI Act. So there is everything around cybersecurity regulation, competition law, for instance, around GPU, but also about models when they are fully integrated with a cloud service provider and with the previous user base from, for instance, social networks. You have environmental regulation. You have product liability with an upcoming EU directive on the topic. You have data protection. Data protection is going to be a huge topic. I contributed yesterday to NIDPB, that is the gathering of the data protection authorities in the EU, meeting with 100 stakeholders that were debating whether there is a risk of memorization within the model, whether the model itself should be considered as personal data or not. Can you use legitimate interest to train a model? So there are many questions, and also on content moderation, because all the synthetic and generated content that is going to be produced by those models, there's going to be a lot of talk around trust and safety, detection when you want to detect sesame content or grooming, may it be on text, on image. There's going to be a lot of talk also around guardrails. So this is something that goes in intersection with the AI Act, but so the AI Act is not the only piece of regulation. Number 9, you need to monitor litigation and case law because you want to know what's being discussed right now. There's a lot of talk around should artists opt out from the training data set. For instance, a few weeks ago in Germany, in Hamburg, there was a super interesting case around Lion 5B, for those who know that image database. And it was considered that Lion did not, as a nonprofit, breach the text and data mining regulation because it was for scientific purpose, but there's going to be a lot of litigation. So you can find pretty much everywhere maps about a taxonomy of litigation around IP, around privacy. It's super interesting to follow, and because also it's like everything is being crafted right now. Last but not least, number 10, Zinedine Zidane, remember, define your AI legal strategy roadmap. So the most innovative decision maker I have the chance to encounter, what they have in common is that they understand they need to integrate AI regulatory in their strategy. Meaning not only like AI compliance, the burdensome stuff about like documenting all the process, but also like AI public policy, AI litigation. So basically all those code of practice we're talking about, how to take part of it and how to frame the conversation. If you're a provider or deployer, you should be cautious about AI procurement because you have to help yourself and your own clients to understand their requirements. And since it's a bit foggy right now, a lot of people don't completely understand what they're supposed to do. So you have to take a deep breath and go into that piece of legislation with the help of anyone. Secure and negotiate your contracts, might it be for data providers if you're using synthetic data or other stuff, but you have to secure them and also set up a roadmap to stay ahead of regulatory development I was talking about. So for your roadmap, if I have to break down in really simple steps, just first identify what AI system model you're using or developing, then determine what obligation you're supposed to meet, check if you're eligible for exception or not. So open source, you might be thinking you're okay for open source, but read the recitals. It's not that easy to benefit from those exemption. Craft your own algorithmic impact assessment. This is like a main important recommendation I would have for you, and set up an internal schedule for implementing those obligations. So as I said, we have time for a small Q&A. If you want to ask your question here or reach out at Entropy, my email is here and the QR code vanishing here. And yeah, this is what we do. Are there any questions you want to ask? Please.
Yeah, it's about the open source model, what we call open source model.
Yeah.
Okay. It's not completely clear about the response. So, and here I'm talking about the foundation model. Okay.
Sure.
Meta is proposing one of their models. Okay, Llama, blah blah blah.
Mm-hmm.
What in my company? Okay. What are the responsibilities that I have to carry?
Okay, the first thing you have to check is the license attached to the model, because there is the marketing approach of saying open source, and then there is a license attached to it. So are we talking about open weight, available weight? What kind of open source license? Is it Apache 2.0? Is it another one? What is the level of contamination of using some kind of GPL open source license or not? So the first thing is you have to read the license, because maybe you can train. Imagine you use that model and you're generating outputs from this model. Can you use those outputs to retrain your own model or to fine-tune it? Maybe you can, maybe you cannot. Maybe it's only R&D, maybe you can do it for commercial purpose. So it's pretty different. This has to be checked before using the model. So you have model lineage, data lineage, you have a lot of different, scorecard and stuff like that you have to check. You just took an example of a famous operator, but there are some also other operators that are telling that they are using a model without saying which one. So this is what I was referring to about model lineage. So first check the license, then see the compatibility of this license with your use case. There are many other answers to that question, but that would be the first step.
And maybe just to complement with regard to the license.
Sure.
We see, for instance, that Llama 3.1, okay, has not the same license as Llama 3.2 because, for instance, 3.2 is not authorized for the time being in Europe.
Yep.
But just also to mention.
Yeah, there is also an entire discussion on that. This is where you should care about AI regulatory in your strategy because it's the conversation around is regulation stifling innovation or not, and what are the check and balances. So that's a good example. Some of the companies saying that they are not going to address, for the moment, the EU market. So this is why also in time of political changes, you have to follow and monitor those topics. Yes?
Compared to GDPRs, is there the same, so there is the same fine, there is the same extraterritorial scope, but is there also the same flows, like for example, if you, for GDPR, if your users are all outside Europe, but your data is from user inside Europe, then you can, like Lucia, then you are not subject to GDPR. Are there the same flows?
So GDPR will still apply because GDPR applies regardless of the technology. Then the GDPR debate is pretty complex because the GDPR is like you have to know the purpose beforehand, whereas when you do AI, most of the time you don't. GDPR, you have to do data minimization, whereas AI needs big data. So there are lots of paradox in between the two. So the first thing is data protection authorities are going to do a lot of guidelines. The CNIL in France just opened a consultation that ended in the 1st October. So we are waiting for some AI fact sheet on those topics. And then, so this is just like data protection with AI. And then you have the AI Act that has similarities, as you underline, on the scale of the sanction or the extraterritoriality, but it's a really different approach because GDPR was about the free flow of data and granting affected person personal rights on like the right to be forgotten, stuff like that. Whereas in AI, of course, maybe some people will use that piece of legislation to do some litigation or whatever, but it's less about fundamental rights and more about the requirements in relation to fairness, cybersecurity, environmental impact before putting the AI system on the market. So it has not the same approach. It's not the same kind of legislation, but the two are going to be analyzed together. And there are going to be a lot of discrepancies in between a lot of the DSA, Digital Services Act, GDPR, and AI Act, because some of the requirements are a bit, by essence, paradoxal. That's just a quick answer, but we can talk about it. Thank you so much for your time. Thanks again.